Rebecca Long-Bailey.
Thank you, Mr Speaker. I will speak to a number of amendments in my name and that of my honourable friends. New Clause 12, which would require the Government to report within 1 year on the impact of the criminal offences relating to offshore income, assets and activities which are created by Clause 165. Amendments 167 and 168, which will make it compulsory rather than just possible for HMRC to publish the names of those that hide behind entities such as companies and trusts when committing offshore tax evasion. Amendments 171 to 173, which expand the definition of reasonable, referred to in Clause 165, to include an honest belief that all of the information included was true and accurate, because we're concerned on this side of the House that the category of reasonableness is on its own far too subjective. Amendments 163 and 164, which would strengthen the penalty for enablers of offshore tax evasion to include 100% of the fees received by the enabler of the service, and for those lawyers in the chamber today, the principle of just enrichment, as it were. Now, the aim of this is to neutralise somewhat the commercial aspect of the tax avoidance industry. Amendments 165 and 166, which increase the minimum penalties for inaccuracies, failure to notify a charge to tax or failure to deliver a return in relation to offshore matters and transfers by 15% rather than the government's suggested 10%. Now, in its consultation strengthening civil deterrence for offshore evaders, the Government considered increasing the minimum penalties by 15% rather than 10%. So this is more of a probing amendment, really, to find out why the Government opted for the smaller increase than it initially considered. And up next we have Amendment 170, which would increase the asset-based penalty introduced by Schedule 22 from 10% to 15%. The Government's consultation on this penalty cited different rates of such an asset-based penalty across the world, including Italy, where the penalty is up to 15%. The opposition think, as I'll expand on in a moment, that we must be world leaders on stamping out tax avoidance, and so I think our penalty should be at the very least on par with precedents across the world. Now, these penalties, Mr Speaker, are indeed a start. However, I would also add that in light of the latest government consultation in relation to tackling offshore tax evasion, which would introduce a separate offence not covered by the scope of this bill, there appears to be a clear move by stakeholders to suggest that even higher penalties are required, and I would urge the Government to consider the suggestions there very, very carefully. I would also like to confirm this side's support of cross-party Amendment 145 on public country-by-country reporting, which was tabled by the Right Honourable Member for Don Valley. And I'd like to place on record my thanks to her for the hard work she's put into pressing this very, very important issue. And I think it's testament to that hard work that many members across the House, including members of PAC and more than 60 MPs, and 8 political parties, as the Right Honourable Member illustrated, plus organisations outside of this place have supported this amendment, and it really is testament, as I've said, to the hard work that she's put into pressing this issue. Now, I won't go over the ground that the Right Honourable Member has covered already. I think she's put her case rather articulately, but this enabling power will ensure that the UK has the scope to strengthen its influence on international tax transparency negotiations, and it will build a greater consensus. Now, finally, new Clause 13 would require a comprehensive report into the UK tax gap, which is defined as the difference in any financial year between the amount of tax HMR should be entitled to collect and the tax actually collected, with such difference deriving from tax avoidance and evasion. Now, the contents of the report is as set out in the amendment text and must be carried out in consultation with stakeholders. It intends to examine a number of areas relating to tax avoidance in the hope that the Government might review its policy and tailor the same in relation to adequately dealing with such issues. And very briefly, for the benefit of members present at the moment... Yes, I will indeed.
Shadow Minister, for giving way. In terms of new Clause 13, would it not also
expose the idiocy of closing HMRC offices, which the government are planning to close 90% of them? And would it also allow members to look at the number of staff in HMRC dealing with tax avoidance and, of course, the number of staff in DWP 3,765 who are dealing with 1.2 billion of so-called social security fraud?
The honourable member makes a very good point, and it is the intention of this report to highlight any deficiencies that might be found in resource or structures within HMRC in terms of their ability to tackle tax avoidance. And as members who will read the amendment will see, the particular point relating to HMRC goes into quite a lot of detail. Just briefly, though, I'll touch on some of the points that the report will require. Firstly, it will require figures relating to UK tax gap for the past 5 financial years, details of the model used by HMRC for estimating the UK tax gap, an assessment of the HMRC's efficacy in dealing with the UK tax gap, details of tax revenue benefits of engaging only companies registered in the UK for tax purposes in public procurement. It will also require an assessment of the efficacy of the general anti-abuse rule in discouraging tax avoidance. It will require consideration of the benefits to tax revenue from introducing a set of minimum standards in relation to tax transparency for all British Crown dependencies and overseas territories. And finally, it will require an assessment of the impact on tax revenues of establishing a public register of all trusts located within the UK, British Crown dependencies and overseas territories. Now, Mr Speaker, the amendments we've tabled today are necessary now more than ever, and I appreciate that we're limited in terms of time today, and as such we'll only be pushing new Clause 13 to a vote, and as I've said, we'll support the Right Honourable Member for Don Valley should she wish to push her amendment to a vote. We also support new Clause 7, which has already been articulately outlined by the Honourable Member for Kirkcaldy and Cowdenbeath. Now, in terms of the other amendments that I've referred to, I do hope the Minister will listen very carefully to the comments that I have made throughout my speech today. The Government will have ample opportunity outside the scope of today's bill, if indeed the will is there, to implement many of the requests that I've made. Now, Mr Speaker, I'll explain the rationale behind our various amendments today. The law on tax avoidance has been greatly influenced by the words of Lord Tomlin in the case of Duke of Westminster versus the Inland Revenue Commissioners in 1935. Now, Lord Tomlin decided that it's the right of every Englishman to organise his affairs so as to minimise his liability to tax, an idea that sadly fuels the tax avoidance industry even today. Now, Mr Speaker, in this age of so-called austerity, with pressure on the NHS, on the armed forces, on our teachers, our young people, the list goes on. Quite frankly, it's not acceptable to seek to avoid your taxes. Indeed, I think honourable members of all sides of this House have come to agree that tax avoidance is something that should be fought. The trouble is, however, that this government has failed to tackle the problem head-on, and simply tinkering about with piecemeal bits here and there, and this finance bill is no different. What we need to see from this government is a real commitment to an overarching strategy that provides genuine legal teeth to tackle the millionaire dodgers and the advisers who surround them. Now, if I may take members on a little historical magical mystery tour, it was judges, not Parliament, in the 1980s who developed a principle which did actually put a dent in the tax avoidance industry, the so-called Ramsay Doctrine. Now, the principle provided that artificial tax avoidance schemes should be analysed as a whole instead of analysing each piece separately. This meant that clever tax schemes could be dismantled by taking all of the artificial elements out, and what was left would be taxed as though the artificial elements had never existed. Now, the effect was huge in terms of attacking tax avoidance schemes. But unfortunately, however, over the years, case law has moved on somewhat, and we've now returned to a world in which tax law is now considered to be entirely a matter of statutory interpretation. There are no general principles at work which can be used when interpreting legislation to combat tax avoidance in practice. And in addition to this, our tax statutes are extraordinarily long, and they are very, very detailed. Now, this is meat and drink to tax specialists. And anyone in this house my age and above might actually remember the Peanuts cartoons. And there's an episode that I remember in which Linus says, "Now I know the rules, I know how to get round them." Now, Linus could have been a tax lawyer. Tax lawyers love playing with the rules, and we shouldn't underestimate the expertise and determination of the tax avoidance community. In fact, one tax law specialist told me recently about something really harrowing about a firm of accountants in the 1990s. There was a specific piece of legislation that was drafted to tax any trust which shifted offshore. And the exception to that rule arose if one of the trustees died and the trust shifted offshore as a consequence. Now, these accountants canvassed a cancer ward to see if the relatives of people dying of cancer would be prepared to have their dying family member signed up to act as a trustee of their clients' trusts. They sought reassurances that the patient would die soon and promised to pay a small fee. Now, this is an extreme case, but it's an example of the depths to which people will sink to avoid paying their taxes, and how loopholes in particular can be found in the depths of legislation. So what is needed, therefore, is a complete reorganisation of our tax avoidance laws. We need a general anti-avoidance principle which is broadly drawn so that it will empower the courts to interpret all tax laws purposefully. This is something which many of us on this side of the House, and indeed the TUC, have been calling for, but the government's attempts thus far have been piecemeal at best. Now, to continue my history tour, in terms of a general anti-avoidance principle, firstly, we had the narrow rule in the Finance Act 2013, which focused only on abusive arrangements. Now, these arrangements had to be considered to be unreasonable by a panel of industry tax experts before HMRC could act. Now, this is an obvious example of poachers in the form of a panel of industry tax experts being established on how to advise on how to actually catch poachers, essentially. Alternatively, we might think of them as turkeys being asked to advise about the menu for Christmas lunch. Now, secondly, in this government's timid tax avoidance legislation, we had a slight broadening out of that rule to impose penalties on avoiders. Thirdly, we gained the power to name evaders. Fourthly, we have provisions to catch those who enable tax evaders. And now there is a consultation on whether those who enable tax avoiders should be treated similarly. Now, it's all far too slow and it's far too little. And as the Minister notes, by the number of amendments we have made today and on previous occasions in this House, the legislation doesn't have the strength or clarity it deserves. Now, we can continue to tinker about with successive finance bills, trying to stick plasters over our deficient tax legislation, or we can develop a comprehensive tax avoidance strategy with heavyweight legislation to match. Now, the Labour Party's tabled new Clause 13 to encourage the government to carry out a wide-ranging report into the UK tax gap, as I mentioned earlier. And it's hoped that this report will help the government to assess carefully the current pressure points and areas of weakness in its current tax avoidance policy. Now, we're limited by the scope of today's finance bill into calling for a report specifically, but Labour is committed to a full public inquiry on this matter, and I would welcome the Minister's support of that. Now, this whole sorry mess, from the exposure of offshore tax havens with the Panama Papers, through to the largest corporations in the world paying next to nothing in tax, investment banks using financial instruments to avoid tax, and clever tax advisers designing off-the-peg avoidance schemes, this needs to be exposed to the disinfectant properties of daylight. And it needs disinfectant, Mr. Speaker, because, quite frankly, it stinks. We need transparency in our tax system. We need a full inquiry to help us design a system which will really challenge the tax avoidance industry, and we need to fundamentally change the way in which we organise our tax laws so they are based on broad principles which make it difficult to avoid them. Then we must fund and equip HMRC so that they can actually take the fight to the tax dodgers by arming them with better tax statutes and by staffing them with more highly qualified staff. We must provide them with real support in combating tax avoidance. The Panama Papers is a symptom of another well-known disease. Many of the world's most appalling tax havens are British overseas territories or British protectorates. And we've got to recognise that we have allowed this to happen. Labour's new Clause 13 essentially asks the government to explore the creation of a set of minimum standards in relation to tax transparency for all British Crown dependencies and overseas territories. Further to this, it's imperative for the Foreign and Commonwealth Office to work seriously with Crown dependencies and the British overseas territories to establish genuine information sharing, to be transparent about the ownership of trusts and companies in their territories, and to stop enabling the tax avoidance industry to flourish on their shores. By allowing the super wealthy tax dodgers of the world, quite frankly, to moor their super yachts and their money in these places, we ensure that billions of pounds, dollars and euros are lost to the public finances of the world. And as a result, hospitals are not built, schools are not refurbished, jobs are lost. Misery and deprivation in our communities here in the UK is caused by tax avoidance. So it's time to stop taking piecemeal action in fighting tax avoidance. It's time the government dealt with the problem head-on. If the government actually wanted to do anything about the tax avoidance industry, then it would lift its head up from fiddling about with the detail of successive finance bills, and it would agree to the amendments we've tabled today. The Labour Party is calling for the new Britain, which will soon be making its way out of the EU, to take a central role in the OECD initiatives to fight corporate tax avoidance, like the base expansion scheme to fight transfer pricing and other corporation tax dodges, to support the EU's recent initiative to confront billions of dollars that are being avoided by the world's largest corporations. Mr. Speaker, we must stop this game that the tax dodgers and their well-paid advisers play with HMRC. We've got to stop this warped and dysfunctional dance between them in which sweetheart deals are done with companies like Vodafone, Google and Goldman Sachs. We must invest in HMRC. We must simplify our tax codes, and we must build our laws on the simple principle that being a part of our society means paying your fair share towards the upkeep of that society. Now, if members of this House are in agreement with those very basic principles, then I'd urge them to support the amendments we've put forward today as a small step towards this goal. Ultimately, however, I hope the Minister has listened very carefully, because we certainly deserve much more than the few tax avoidance provisions contained within today's bill. And I would like to formally move new Clause 13.